Bar Rules Series.
Criminal law.
Criminal intent. General intent. A general intent crime is one in which the defendant needs only to intend to perform the act, not the result of the act. Specific intent. A specific intent crime is one in which the defendant must not only intend to perform the act, but also intend the result. Transferred intent. Transferred intent applies when harm intended for one victim object occurs to a different victim. Defenses can also transfer. Charges include both 1. Attempt to commit the original crime and 2. The actual crime. Merger doesn't apply. Crimes against person. Homicide. Common law murder is the 1. Unlawful. 2. Killing of another person. 3. With malice aforethought. Malice can be established by showing 1. Intent to kill. 2. Intent to commit serious bodily injury. 3. Reckless disregard for human life. Depraved heart. And felony murder. Felony murder. Under the felony murder rule, the defendant is liable for murder if 1. They had the intent to commit an inherently dangerous felony such as burglary, arson, rape, robbery, or kidnapping, and 2. A victim dies. 3. During the commission of the crime. Felony murder does not apply if a criminal accomplice dies. If a bystander is killed by police, the majority view, agency, is that the defendant is not liable. Under the minority view, proximate causation, the defendant is still liable. Causation. The defendant's actions must be the actual and proximate cause of the victim's death. Transferred intent, as in tort, applies. Voluntary manslaughter. Heat of passion. Murder can be reduced to voluntary manslaughter if 1. The defendant killed in the heat of passion. 2. Where they acted in response to a provocation that would cause a reasonable person to lose self-control. 3. There was no time to cool off. And 4. The defendant acted while so provoked. Imperfect self-defense. Murder can be reduced to voluntary manslaughter if the defendant acted under an unreasonable mistake about the need for self-defense or the defendant started the altercation. Involuntary manslaughter. Gross negligence. The defendant acted with gross negligence, meaning a reckless disregard for a substantial risk of harm, and a loss of life resulted. Misdemeanor manslaughter. The defendant intended to commit a misdemeanor or nonviolent felony and a death accidentally resulted. Statutory murder. First-degree murder. First-degree murder occurs when the defendant kills another human in a deliberate and premeditated manner. Deliberate means the defendant acted in a calm and dispassionate manner. Premeditated means the defendant had time to reflect, even if only briefly. Second-degree murder is all other murder. Assault. Assault is either an attempt to commit a battery or an act intended to cause a reasonable apprehension of imminent contact. Battery. Battery is the 1. Unlawful. 2. Application of force. 3. Against the person of another. 4. Causes bodily harm or offensive touching. It is a general intent crime. Mayhem. Mayhem is the intentional dismemberment or disablement of a body part. Kidnapping. Kidnapping is the unlawful confinement of another, involving movement or concealment. Theft. Theft crimes are specific intent crimes. The defendant must intend the result. Larceny. Larceny is the 1. Trespassory. 2. Taking and carrying away. 3. With the intent to permanently deprive. Larceny by trick occurs when the defendant obtains possession through fraud or deceit, not trespassory. Embezzlement. Embezzlement is the fraudulent conversion of property by a person who is already in lawful possession of it. False pretenses. Theft by false pretense is obtaining title through a false representation of a material fact. Robbery. Robbery is larceny from the person or presence of the owner through force or fear. Burglary. Burglary is the nighttime breaking and entering of the dwelling of another with the intent to commit a felony therein. Nighttime. Nighttime is after sunset when it has become dark. Breaking and entering. Breaking and entering occurs when a person uses force to enter a building without authorization. Dwelling. A dwelling is a structure where someone resides. Extortion. Extortion is the deprivation of the property of another by threat of future harm. Receipt of stolen property. Receipt of stolen property is the knowingly receiving stolen property with the intent to deprive the rightful owner of it. Arson. Arson is the malicious burning of the dwelling of another. Inchoate crimes. Inchoate crimes are specific intent crimes. Solicitation. Solicitation is requesting or encouraging another to commit a crime with the intent that the person solicited will commit the crime. Solicitation is complete upon the request and does not require an agreement. Conspiracy. Conspiracy is 1. An agreement, 2. Between two or more, 3. To commit an unlawful act. The agreement can be implied or inferred. Under common law, the conspiracy is complete when the agreement is made. But modernly most jurisdictions require an overt act to form the conspiracy. Jurisdictions that recognize unilateral conspiracy criminalize a conspiracy even if the second party is an undercover police. Co-conspirator liability. Co-conspirators are liable for the crimes of co-conspirators if the crimes were committed in furtherance of the objective of the conspiracy and were reasonably foreseeable. Withdrawal. Once the agreement has been made, a conspirator cannot withdraw from the conspiracy. However, the conspirator can limit liability for future acts if they communicate withdrawal to the co-conspirators and take affirmative action to withdraw. Notify authorities. Attempt. Attempt is 1. An affirmative act beyond mere preparation. 2. Which involves a substantial step or dangerous proximity to complete the crime. 3. With specific intent to commit a crime. Merger. Solicitation and attempt merge into the actual crime, so cannot be additional charges to the actual crime. Conspiracy does not merge and can be an additional charge. Defenses. Factual impossibility is not a defense. Legal impossibility is a defense. Accomplice liability. Accomplice. An accomplice is one who aids, abets, or encourages with the intent that the crime be completed. Liability for an accomplice is to the same extent as principal. Mere knowledge is insufficient. The accomplice is liable for additional crimes if they are the natural and probable consequence of the intended crime. Accessory after the fact. An accessory after the fact is an accomplice who gives assistance to avoid apprehension after the crime. The accessory is not liable for the crime. Modernly, the accessory is only liable for obstruction of justice. Withdrawal. A withdrawal by an accomplice will only be effective if the accomplice 1. Has undone the effects of his assistance or encouragement, and 2. Does so before the chain of events becomes unstoppable. Defenses. Self-defense. A person may use 1. Reasonable and proportionate force. 2. If they reasonably believe it is necessary to defend against threatened harm. Deadly force may be used only if there is a reasonable belief that the actor is facing deadly force. The majority view is that there is no duty to retreat. Even the minority view does not require retreat when in one's own home. Castle doctrine. Defense of others. A person may use 1. Reasonable force to defend others. 2. When they reasonably believe that the defended person would be justified in using force. A minority of jurisdictions require that the defended person would actually be justified in using force. Imperfect self-defense. Defense of property. A person may use a reasonable amount of force to defend property but may never use deadly force. Voluntary intoxication. Voluntary intoxication is a defense only to specific intent crimes where the level of intoxication negates the forming of the requisite specific intent. Involuntary intoxication. Involuntary intoxication is a defense to all crimes if the defendant could not form any intent. Duress. Duress arises when a third party threats a defendant with serious bodily harm or death. Duress is not a defense to intentional murder, but it can be used as a defense to the underlying felony in FMR. Mistake of fact, law. Unreasonable mistake of fact. Defense for specific intent crimes. Reasonable mistake of fact. Defense for general and specific intent and malice crimes. Mistake of fact is not defense for the strict liability crime. Mistake of law may be a defense for specific intent. Insanity. 4 tests. Monotone. The defendant does not understand the nature of the act or that the act is wrong. Irresistible impulse. The defendant is unable to control their conduct. Durham. The defendant's conduct was the result of mental illness. MPC. Combine first two. The defendant did not understand the nature of the conduct. OR could not conform their conduct to the law.